Hello, good afternoon. My name is Lydia XC Brown, pronouns they, them. I'm a youngish East Asian person with short black hair and glasses, wearing a blue shirt and dark jacket. And behind me is an image of some really beautiful blooming white orchids. I am a policy counsel on privacy and data at the Center for Democracy and Technology, as well as a special advisor to the Disability Rights Committee within the ABA Civil Rights and Social Justice section. Today, we're thrilled to be presenting a timely webinar titled Algorithms, AI, and Disability Discrimination in Hiring, Complying with the ADA, or Americans with Disabilities Act. Our panel is sponsored both by the ABA's Commission on Disability Rights and the ABA section of Civil Rights and Social Justice, and is one of many in a series of rapid response webinars. We're actively planning additional programming on a variety of areas, so please visit americanbar.org/CRSJ for updates on these programs. During today's programs, we encourage you to ask questions of our panelists through the Q&A, not the chat function. Again, that is the Q&A button at the bottom of your taskbar and not the chat function. If you do not see the controls, please ensure that your screen is not idle. You may need to move your mouse around in order to have the taskbar pop up again. I will be monitoring the Q&A, and we will do our best to address those questions, time permitting. We will be sharing a recording of this program with everyone who has registered so that you can share it widely with your networks and watch it again if you just really enjoy the conversation, which I hope that you will. I am very excited today to be able to introduce our three speakers very briefly. We have Draydear Roberts, who is General Counsel at the Core States Group, Riddhi Shetty, who is my colleague on the Privacy and Data Project, also a policy counsel at the Center for Democracy and Technology, and Pierce Blue, who is of counsel at Morgan, Lewis, and Bockius. Just realized I didn't ask you how to pronounce that. Bockius, LLP, a law firm that I do not know how to pronounce. And I'm going to ask each of you to start off by addressing a little bit about the topic today for those who may be a little bit less familiar. We use terms like algorithms and AI pretty frequently in our work, and they appear constantly in the news now, but many people may not know what the difference is. So these words might bring up certain images for the average person that may or may not reflect what we're working on. Can you talk about what kinds of algorithms, AI, or software tools employers are actually using in hiring and worker management? What are they, and how do they work? Pierce, why don't we start with you?
Sure, happy to jump in. So I think what you see a number of employers using at this stage are a number of different varieties of AI tools, machine learning tools. Predominantly, what I have seen most in my practice are tools that help the employers sort through a vast array of applications, but including maybe people who have applied in the past for certain jobs but haven't received them. And typically these tools then produce a ranking or an output or potentially a score, which would help recruiters then determine which positions might work best for an individual, or whose fit might work best. To a lesser extent, you will see some employers using game-based software or video-based software to evaluate candidates. And then I think to an even lesser extent, you will see employers using tools that essentially remove a human decision-making from the process entirely. At least for most of the clients that I deal with, they're not quite at the stage where they're letting the algorithms run wild and do the work themselves. They're using it as a tool to assist them in that process, particularly those who get large volume applications, but not yet have replaced the human in the process yet.
And Riddhi, would you be able to share a little bit about this as well?
Yeah, absolutely. So some of the other tools that we are particularly focusing on putting to what Pierce just discussed with respect to gamified tools, also video interview analysis tools that will capture how an applicant is moving, speaking during the course of answering interview questions, tools that mine through the language in resumes to determine whether the resume reflects characteristics that are more commonly found in the resumes of those that have been previously selected by an employer. And then outside of the hiring or selection context, there's also the worker management component. For the employer's existing workforce, there are potential biases that arise with algorithm management tools that are used to monitor and increase workers' productivity and performance, for instance, by tracking the time that they spend on certain tasks or the time spent off tasks, the number of lengths of breaks that they take, their movements and their locations, and even sentiment analysis of workers' conversations with customers and more. So all these different tools will similarly capture how a worker is moving, where they're moving, how they're communicating. And all these can be used to determine whether any kind of disciplinary action is necessary or any kind of corrective measures are necessary with respect to how a worker is being or not being productive enough in meeting productivity rates.
Thank you for sharing about that. Some of these software programs are frankly terrifying, especially for me, just thinking as a disabled person who is also an advocate and a policy expert. But just knowing there are so many ways that people who come from different marginalized communities might interact with these tools, it's scary to think how employers and managers might be increasingly relying on automation to make assessments about my fitness for a job or my performance when I'm actually on the job. So on the topic of discrimination, all of us have done work in some way or another on employment discrimination. And we know that employment discrimination isn't new. Employment discrimination has been around for a while. It has affected people from a range of marginalized communities and communities of color, the LGBTQ community, women, and disabled people, not to mention immigrants and people from minoritized religious communities, just, to name a few, right? But what makes AI or automated tools particularly problematic for disabled people who are applying for jobs or who are employees? And let's go to Dradier first.
Yeah. First of all, the biggest problem is probably how the employer plans on using it in the first place, and you get a tool that measures what the goal is, which is speed. So if you're using a tool for speed, you're not using it, and you're not using a tool for the best candidate, which is what they allege. You're going to get a tool that maximizes efficiency and doesn't take the time to make sure that includes everyone. So that's the biggest problem. I mean, the marketing is that you'll get a better candidate, you'll find the candidate you want faster, but you really will just find a candidate faster. That's one issue. The other issue is that you don't really get the negative data. So this is really about data analysis. You don't get the negative data of the people that you passed on that went on to another job and did well. And so you have the false sense of an echo chamber of this tool is doing really well. We did hire that person that this tool suggested. And so it's going great, but you don't know the people that you're stupidly leaving out and passing on who could be great. And the other issue is that most of it, especially in the beginning, is automated, and someone doesn't know to reach out to ask for an alternative because their first engagement with an employer will likely be digital, and very specifically digital, whether audio or email. And so you're not really meeting someone, talking to someone on the phone, having that opportunity to express that an accommodation or any kind of specific accommodation is needed.
This is Lydia. Thank you for sharing that. And of course, one of the troubles is that disabled people may not necessarily, be able to determine how exactly the tool is functioning, but even more than that, disabled people may not know in all cases that they have a qualifying disability, or even if they do, may not feel comfortable asking for an accommodation and disclosing, because while we are protected from discrimination on the basis of disability in the hiring process, that doesn't mean that discrimination doesn't still happen sometimes, maybe more often than some people might like to admit or realize. Rithi, would you be able to address a bit about this as well? How disability is affected, and specifically how disabled people are affected by these types of tools?
Absolutely. Consider just how some of the tools we've already mentioned actually can play out for a disabled applicant. For instance, as you mentioned, a lot of the issues that we're talking about have long existed. Employment discrimination is not a novel issue, but these tools are doing what employers have done, just doing it in a way that makes it less visible when it comes to the employer's role in that discriminatory process. So for instance, you think about resume mining tools. They can incorporate machine learning to kind of recreate patterns in the resumes of employees that have been considered to be top performing employees, or the resumes of candidates that were previously selected to move forward in the hiring process. So these tools learn to treat candidates' resumes the same way that the employer historically has treated them. They can learn to favor resumes that don't have gaps in employment history that could be a result of disability or caregiving obligations, or absences from the job force because of disability-related needs or healthcare-related needs. Resumes may also not have certain language that indicates like racial affinity or disability. And so those kinds of resumes might have a better chance of moving forward in the hiring process than resumes that may indicate any kind of affinity with a particular protected class. So that can put certain resumes at a disadvantage on that front as well. There could also be resumes that indicate experiences that are not accessible to everyone, such as working abroad or study abroad, work-study programs, athletic participation. So those kinds of things will have a disadvantage for disabled applicants. And the same extends to other kinds of tools like gamified assessments or other kinds of personality tests. They're collecting data from candidates' responses as they're playing this set of games to measure their personality traits or their aptitudes in ways that are not necessarily going to mirror how those aptitudes or personality traits would show up in the job itself, or even would be needed in the job itself in order to ensure sufficient work performance. With video interview analysis, likewise, you have decisions being informed by how a candidate has spoken, their intonation, their facial expressions, and their physical movements. So all of these things are going to contribute to or even create new avenues for disability discrimination.
And Pierce, would you be able to talk a little bit about the context of this conversation on disability discrimination?
In terms of the context, like the legal context, or the
existing issues that disabled people face, that AI tools might be exacerbating or contributing to, but are certainly not by any means the only way in which people with disabilities face discrimination in the workplace.
Absolutely, absolutely. No, and thank you for that, for clarifying for me. Yes, so I think the primary, I think, benefit that the ADA provides, right, is this ability to have reasonable accommodations for persons with disabilities. This is recognition that a one-size-fits-all approach tends to leave out or marginalize individuals with disabilities in particular, because we're not, because there are ways in which they might not conform to the existing sort of model or thought process, and that's a negative that we want to combat. And I think the issue when it comes to AI is the same when it comes to a lot of other selection tools that employers might use on a day-to-day basis. It's that they're designed for a large population. They're designed sort of in a one-size-fits-all fashion, and that doesn't always work with the disability community, and doesn't conform with the legal requirements that exist. So I think one of the most important things, particularly what we've seen in terms of some of the guidance that have come out and some of the legislative proposals, really has been a reminder to employers to take a step back to ensure that there's at least a level of disclosure, so that one, the employees or applicants who are going through this process are aware of the fact that accommodations might be available and can request them, and two, that there's enough information out there so that a person who might not even know exactly when they're looking at this tool how this tool might be evaluating them, they have some clarity as to what factors are being used, what factors are being assessed, so they can evaluate and say and inform the employer that, hey, this, my disability might make it so I don't look so good on this score, and I need an alternative system for doing that. So I think it's a process that employers are used to in some ways under existing law, and it's just about making sure that fits into this new context.
Now, Ridley, turning back to you, would you be able to talk a little bit about the ways in which AI and automated related tools affect people with different kinds of disabilities, both those disabilities that might be readily apparent to an observer or somebody interacting with a particular disabled person, and disabilities that are more hidden and less likely to be easily perceived or recognized?
Sure. So you can think of it both in terms of how these tools actually have to be used, or how the worker has to interact with these tools in order to be completely evaluated as intended, and then the actual criteria that these tools are evaluating. So on the first, you think about the formats in which these tools are provided. And under the ADA, one way in which disability discrimination can occur is when an employer uses a format that will administer the assessment in a way that will tend to screen out people with disabilities. So if you think about, for instance, a gamified assessment where you may have to click a mouse or tap on certain keys on your keyboard, be able to see the screen or hear, and then respond accordingly. People who are blind or deaf may face issues that when they're trying to kind of interact with any kind of stimuli, both visual and auditory, when interacting with these kinds of assessments. If you have a mobility related disability, that might make it harder to be able to respond within the desired time frame that the evaluation is meant to kind of prioritize when selecting candidates that are performing better. And then you have the actual criteria in general, like whether that's even relevant to what the job would require in the first place. So for instance, if a tool is assessing whether you have certain personality traits, for instance, optimism, that's something that anybody can perform, but so you can score highly on an assessment that's evaluating a trait like that, that might not necessarily be needed for good job performance. So to screen out candidates based on these kinds of rather arbitrary characteristics can end up causing people, for instance, who have mental health disabilities or who may simply be emoting differently, who may perform these kinds of personality traits differently. Those people will end up being at a disadvantage because of what these tools are designed to examine. And as another example, if we think about the video interview analysis context, if somebody doesn't maintain eye contact, whether it's because they're autistic or because they have any kind of disability that affects their ability to stare at a screen for too long, these kinds of issues can also cause the software to interpret certain personality traits or infer personality traits based on behaviors that actually aren't relevant to being able to demonstrate those kinds of qualities. So there's this kind of multi-pronged issue, both how these tools are actually available to interact with, and whether there are any alternatives to those kinds of formats, and then also what these tools are even designed to measure, which is also kind of a reflection of the employer's values and what they're looking for in their workforce.
This is Lydia. Thank you for diving a little bit more deeply into that. And, in addition that I would add to your comments, of course, referencing something that I previewed a few minutes ago, are that for people with a range of disabilities, other experiences of discrimination and marginalization will also impact one's engagement and one's interaction with both hiring tools and worker management tools, because somebody who is disabled and has also experienced substantial past discrimination in their employment or their education because they're known to be transgender, or because they're a darker skinned Black or brown person, or because they are visibly brown and Muslim, or because they are a veteran who also has childcare responsibilities, they're going to be assessed differently, both by potential human reviewers and by automated analyses of their resumes, of their appearance and their bodily appearance, their facial appearance, and perhaps even their speech patterns in ways that may not apply to people with disabilities who are perceived as lighter skinned, who are white, who are otherwise perceived as coming from majority groups, are gender conforming, and just not going to be flagged as abnormal or having had abnormal or lesser qualities on their resume or in their application package. And there are numerous examples of research studies done to show the effect of both hiring tools and worker management tools on workers from a range of disenfranchised and marginalized communities. And while there's currently very limited research on the experiences of disabled people disaggregated by other identifiers and demographic groups, one has to wonder what those statistics and outcomes probably would be if we were able to have access to those disaggregated numbers just based on people's lived experiences. Now, turning a bit to the legal context in which we are having this discussion, because this is an ABA program, so we are going to discuss the legalities here. Pierce, can you talk about what requirements existing civil rights and worker protection laws place on the use of these tools?
Yes, happily. As I mentioned earlier, the general rules of the ADA, still apply in this circumstance. It's about transferring those general rules onto this sort of specific area. So, for one, there's going to be the obligation to provide reasonable accommodation. So, if an employee or an applicant requires an accommodation in order to, be fairly evaluated by the tool, or to have including potentially just having a completely alternate assessment system, be fairly assessed in general. That's a request that the employee or applicant can make. There's also the requirement that these tools can't be used to screen out individuals with disabilities. If they are found to be screening out individuals with disabilities generally, they have to be shown to be job related and consistent with business necessity, some justification to show why that's occurring, which is a high bar. And then also, one of the things that the ADA does, and this is not just for persons with disabilities, it's for everyone, is that employers aren't allowed to ask medical questions during certain phases of the employment process. So when you're an applicant and you're in the pre-hiring phase, the employer is not supposed to ask any medical questions. Once you're in the post-offer pre-employment phase, there's a limited room to ask medical questions. And then in the finals, when you're an employee, there's, again, an ability to ask certain medical questions, but they have to be job-related and consistent with business necessity. So those three general requirements all come into play in this field. So when it comes to the medical inquiries part of it, some of these tools, whether intended or not, might either gather information that would be considered medical or would be considered to be information that might reveal something about a disability or show a presence of a disability. It's same with, when someone's when someone's an employee and they're being monitored, in the same way, depending on how they're being monitored. For instance, if part of the monitoring process was, say, heart rate, for instance, which, I've seen in some contexts that would be a medical inquiry. So to do so, you'd have to meet the ADA requirements for when that's acceptable. And then, of course, at any stage of the process, if these were being found to screen out people with disabilities for whatever reason, have a disparate impact on them, or it doesn't even have to be just generally a disparate impact. It could just be that it has a tendency to screen out a certain subset of disabilities. The employer then has to justify those. But those, I think those all play sort of a second fiddle again to the broader obligation, which is reasonable accommodation. That's the big obligation of the ADA. And I think when it comes to these tools, it's certainly as important, if not more important than in other contexts, which is that if you're an individual with a disability, whether you're an applicant or you're an employee, you have the right to request a reasonable accommodation, so a modification to how this process works, an alternative process, something like that. And again, it's why it makes it so very important, and why I think the EEOC guidance on this is particularly stresses this point, makes it so very important for employers to be clear about what the tools are, what what sort of characteristics they're assessing, what factors they're taking into account, so that employees or applicants can then inform the employer that they might need that accommodation. It's really that sort of informed disclosure, I think, is particularly important. Now, of course, the issue with some of these tools is that it's not always clear how they're working and how they're functioning. We talk to folks who know this area really well. They'll say sometimes AI and machine learning is like a black box. That does make it, I think, quite. I think going forward, that's going to be an issue that's going to create some difficulties.
And Dre Deer, would you like to weigh in a little bit on this as well?
Yeah, sure. The black box issue is the biggest one. They don't know why, for the most part. And just the way it works is they go backwards to try to predict going forward. And as a lot of us know, if you go backwards in time for employment, you're going to get less women, you're going to get less Black people, you're going to get less everything. And this is before you can even go back far enough where you lose all these protections like the ADA. So if you're hiring like that in the future and building your workforce of the future based off of decisions you made in the past, you're just going to discriminate because that's what we did in the past and probably now. And so when you're thinking about it, unless a company or a tool has governance and expressly goes out of its way to check for these things, to do a bias check, the tool is likely going to have a problem and is likely going to root out a lot of people, and including people with disabilities. The other thing is, best practice, being in-house attorney, and I'm thinking about how a company mitigates its risk. One of the ways we've done it from a diversity, equity, inclusion standpoint is by having multiple interviewers for an interview. That is to get more perspectives in the room. So someone who might read someone as rude might read the other person as strong-willed. And so you get that diverse perspective on a candidate. Now you go to AI, well, now you've limited to one opinion and you've automated that. As an in-house counsel, I know my good, hiring managers, and I know the ones who could struggle a bit and forget to ask questions. They make sure people get accommodated. Now you don't get the benefit of I need to target these folks and the other ones are really good at it. You get one tool that's going to scale. Your whole company is going to hire like this tool hires, and then to get ahead of it. So again, unless you have governance ahead of time, you're going to have a problematic hiring manager, and then you're going to find out later, likely in a class, what mistakes that one tool made globally at scale for a long time.
Thank you. And I think that helped to address one of the questions that we actually have in our Q&A, which was from Roland, asking how applicants would know if an algorithm is discriminating against them, because it seems that algorithms are invisible. And, that's absolutely right, that, many applicants may not know if or whether an algorithm is being used, and may not know even if they're relatively sure that there's an algorithm being used, if they're directly engaging with it, say what Pierce mentioned earlier about some kind of a gamified test, they might not know for sure if they've been discriminated against, or they might have a sense that they were, but not be able to prove it, which was my experience when I was in high school as a disabled young person applying for job after job I think I remember applying to every job in the local mall, every single store. And all of them had some kind of automated personality assessment as part of the job application. And I filled out the questionnaire incredibly honestly, probably to my detriment, because I didn't get a single call back. Everybody else I knew got hired, except me. I couldn't get hired anywhere. And I can't prove that I was discriminated against by algorithm. And maybe I wasn't, but also maybe I was, because that was a lot of applications and a lot of personality tests. And I was the only one that I knew of who was autistic and had mental health disabilities, who was filling them out among the people who I was talking to about it anyway, and they all got hired. So recently, the Equal Employment Opportunity Commission, along with the Department of Justice, released technical assistance just a few months ago. This technical assistance is aimed at employers on preventing disability discrimination if they are using algorithm or software-based tools. Could you talk about what this technical guidance actually accomplishes? And for this, we'll go back to Riddhi.
Sure. So, there are a few things that the EEOC's technical assistance does well. One is that it affirms that employers are responsible for the impacts of the hiring technologies that they choose to adopt, and also responsible for making sure that reasonable accommodations are provided when these tools are being used, even if the tools are developed or administered by a vendor or other entity. And that's critical because in a lot of cases, it makes it kind of easier for an employer to avoid any obligations to correct or in any way mitigate the impacts of the tools that they're choosing to adopt by claiming that they don't know how the tool works, that they're just using it as the vendor instructed or advised them to. Meanwhile, vendors also can avoid liability by saying that they have advised employers to use the tools in a more limited fashion than the employers actually have for more limited applications. So vendors will argue that these tools are not supposed to be too greatly influential in the overall employment decision, that it's just supposed to be providing one particular factor in the overall decision-making process. But if employers are choosing to rely so heavily on these tools, and these tools are then going to produce discriminatory outcomes, then they should be responsible for those outcomes and for not kind of doing their due diligence in avoiding that kind of risk. Another thing that the technical guidance does is that it advises that workers in effect have requested accommodations when they communicate to employers about the likely impacts of a tool on how they're going to be evaluated. So if they can kind of tell that the way that they have to interact with the tool, whether it's because of the equipment or devices that they have to use or because of what they have a sense that the tool may be evaluating, if they communicate to the employer that they don't think this will evaluate them fairly, or that they will run into challenges in trying to use that tool, that effectively then would put employers on notice that the candidate is seeking accommodations and that should therefore be affirmatively provided. The technical assistance also advises that disability bias requires a more proactive examination of how a tool will be kind of perpetuating disability bias, because it is more complex than other manifestations of discrimination. A lot of the types of disabilities that certain workers may have that affects how they're being evaluated may be harder to perceive, maybe more difficult to test for. And if a worker is hesitant to disclose that they have a disability, then that is not going to be data that employers will necessarily have when trying to evaluate kind of retroactively to determine whether their tools are in fact fair. So using those kinds of statistical approaches may be to an extent effective when you're talking about, for instance, racial discrimination, just comparing, for instance, how many Black people have gotten position versus how many white people were selected. But when it comes to disability, as Piers had mentioned earlier, different kinds of disabilities can end up showing up differently. And that means certain disabilities may end up being the target of discrimination in a way that others are not. The technical assistance also recommends ensuring that algorithmic assessments are tailored to measuring the ability to perform essential functions. So not focusing so much on these other characteristics that are going to be clearly less relevant to what an applicant would actually have to do if given the job. And it advises that an assessment's use can violate the ADA, even if it only tends to screen out candidates with a certain type of disability. But one thing that we would note, workers might not request accommodations for a number of reasons, whether it's because of stigma around their disability or because they don't even realize that they have a disability that could entitle them to reasonable accommodations, or know that accommodations are even available. And many risks of disability bias, as Lydia and Lydia flagged earlier, are a result of or compounded by other targets of marginalization as well. So these are areas that could warrant further guidance from the EEOC, and also more proactive efforts from employers to be thinking more holistically about how discrimination can manifest in the use of these tools.
Thanks for sharing a bit more in detail. And I would add to that that one really clear limitation that you just alluded to that I hope will be addressed in future guidance coming out of the EEOC and DOJ is the impact of these kinds of tools on disabled people who belong to other marginalized communities. I found it very helpful that the guidance illustrated examples of discrimination with very specific anecdotes and stories that would give a very clear example to someone reading to better understand what kinds of tools could discriminate, how they might discriminate, and what employers might be able to consider doing differently. But not a single one of those examples addressed the experience of compounded discriminatory effects because that's of course a major gap because disability is more prevalent in other marginalized communities and disabled people exist just by definition in every single community, whether that community generally experiences systemic discrimination or not. We are literally part of every other community. So I'm hoping that there will be future guidance that very explicitly addresses that gap and helps to begin filling it. Now, relatedly, we think about algorithmic bias in employment, both in hiring and in worker management, as its own distinct area. But these types of decisions and, of course, discriminatory functions, discriminatory patterns, and discriminatory practices in algorithmic tools and employment are not removed from discrimination and the impact of algorithmic and automated decision-making in other areas. For instance, in access to housing, education, public services, credit, and others. Would you all be able to talk a little bit about the connections between algorithmic bias in employment and other forms of automated decision-making? We'll turn to Dradier.
Yeah, sure. First, for the AI developer, right? A lot of the times they'll tell you that, hey, can we share the data that we collect for you using our tool to help make the tool for you better for everyone, right? And that's how you know that they will be selling to other people the data. And so it could be the same developer is selling data to education and housing and all those other algorithms. So if you got rejected for a job for being a bad candidate, that could also impact you elsewhere and sort of just keep growing this algorithm to keep weeding you out everywhere and not just in that one application. So that's one way that it can spread because data is being sold and shared in dark rooms back and forth to each other into different service areas where you might be running into the same algorithm with completely different companies and for completely different reasons.
And Pierce, would you be able to elaborate a bit on that as well?
Yeah, I'm happy to. I mean, I think there are some obvious examples of how data and scores collected in one context and then can be transferred over to another. So we think about, say your credit score or something like that. Which then can then be used in the employment context. How's your credit score created? Well, that's partially algorithmic in nature. And so then, your one's poor credit score could then impact your ability to get employment. And so it's really important for, I think, for employers and for developers when they're creating these systems to take a step back and think about how some of the inputs that they might be thinking about using, how some of the data inputs from other sources, whether that's credit, whether that's housing history, could somehow have incorporated discrimination into them along the line. I think that there's a little bit of there can be a divide, there's something, at least a small divide that I've seen in my limited interactions with folks who are in the sort of AI tool development world. I think some of them are less versed in some of these discrimination type issues, and their focus is more on let's get the best data tool, right? Let's get this, and it's sometimes it's hard to get them to take that step back and say these are other concerns or these are things you really should take into account. So it can be an interesting process trying to work that in. into the analysis. But I think it's really important certainly for employers who are going to then later use these tools to ensure that they're not then caught up in litigation related to it.
Thank you for sharing that. And I think that's really helpful for the attorneys who are here now to know and to just have in mind. Now, looking at where the future legal landscape will be, can you talk about how agencies should build on our existing legal protections against discrimination and improve accountability in employers' use of automated decision-making tools? Let's go to Riddhi.
Sure. So one of the biggest things is that the EEOC's technical assistance comes after kind of a long stretch of employers and vendors relying on the uniform guidelines for employee selection procedures, which were issued back in 1978. So they are not only not up to speed on the kinds of modern tools that we see being used now, but they also aren't intended to address disability discrimination and aren't really effective. You think of, for instance, the 4/5 rule, which is one metric that vendors tend to rely on, which is essentially that the selection rate for workers belonging to a certain protected class has to be at least 4/5 of the selection rate for workers who are not in that protected class. That kind of, it's a really rather rudimentary approach. It's arguably not even effective for the types of discrimination that it is intended to help examine, like racial discrimination and gender discrimination. So on top of that, to try to use something like that for disability discrimination is just not feasible when you're also considering not only how many different types of disabilities applicants may have, but also how those disabilities can manifest differently and intersect with different other marginalized identities that an applicant has, and that can be effective in the way that these tools work. So that's one of the benefits of the technical assistance that was released this year. But also more recently, the White House issued the Blueprint for an AI Bill of Rights, which is essentially a framework of about 5 principles that guide the use of automated systems across every sector, really. And these principles are that the system should be safe and effective, that they should be designed to avoid algorithmic discrimination, that they should protect data privacy, that they should provide effective notice and explanation, and that they should provide for human review or alternatives to the use of the automated system itself. And different agencies have started, even prior to the release of the blueprint, have started incorporating a lot of these principles in their own efforts. So for instance, the EEOC, the Equal Employment Opportunity Commission, is one of the most active on this issue. They initiated their algorithmic fairness initiative late last year. And the more recent guidance really followed several months of stakeholder engagements and conversations. And in addition to the existing algorithmic fairness initiative, the EEOC is also working with the Department of Labor on the hiring initiative to reimagine equity. And that in that initiative, algorithmic practices and tech-driven practices are also a priority in kind of rethinking how we talk about equitable access to jobs and ability to kind of advance in employment. So we see agencies kind of applying these principles to the way that they're discussing algorithmic fairness, and a lot of these principles should also be incorporated going forward across the board, both at the agency level and by employers and vendors directly too, and they can really help to improve accountability and how these tools are being used.
Thanks. And Pierce, would you be able to talk a little bit about this as well?
Yeah, absolutely. I think that, again, I also give a shout out to the EEOC's AI and algorithmic fairness initiative. I think that was, I think that's a really good model of an agency taking a really in-depth and serious look into these issues related to what existing legal protections are there. I think that just as Riddhi had said before, what's fascinating about AI and disability is that the notion of a simple bias audit really just isn't effective in this context. And I think one of the primary policy responses that you've seen in response to the growth of these tools has been this idea of a bias audit. New York City has a bias audit law that's likely to come into effect in January of next year, or is slated to come into effect in January of next year, that requires companies that are using they're posting jobs in New York City to have and using AI to have a bias audit that people can look at and see, whether the tool they're using has produced biases in the past, and that provides you with some information in relation to discrimination on the basis of, say, sex or race. But with disability, because you have this notion which the ADA incorporates of this, essentially what's called a disparate impact in a single case scenario, which typically think of disparate impact, that's a large number of individuals. The ADA, you can have a disparate impact of one, where if there's a particular individual, because of their particular disability, and their particular combination of limitations, if they are being screened out, the employer then still has to justify that test or whatever method they're using as job related and consistent with business necessity, the same way they would have to do if there was a finding that they were using a tool that was screening out X number of people on the basis of gender. And that's just a reflection of the fact that every disability is unique and all the limitations it imposes are unique. And that's what I thought was, I think, the one of the main messages of the EEOC's technical assistance really was to have employers take that step back and remind them that it's not it's very difficult to take that sort of one size fits all approach in this AI context when it comes to disability.
This is Lydia. I'm now wondering about what the experience is of disabled people who are worried that their rights under the ADA and other protections might be violated. What should people do if they believe or know for sure that they are being discriminated against because of an algorithmic tool used by an employer where they're hiring for a job, or by an employer where they are currently working? And we're going to go straight back to you, Pierce. But before you answer that, just a reminder that if you have any other questions and you're an attendee, please add them to the Q&A, not the chat. And because this is our last question, and then we'll turn to yours. So Pierce, what should you do if you are disabled and you believe that you might be being discriminated against by an algorithm?
Yeah, certainly. If you are sure that, or very certain from your interaction that this tool didn't give you, say, the opportunity to request an accommodation, or you requested an accommodation and there wasn't an opportunity to engage in a dialogue, or simply was denied, your recourse is to file a charge with the EEOC. And you have between 180 and 360 days from the event that occurred to go and do that. You don't need a lawyer to file a charge. It's pretty simple. You can call up your local EEOC office and they can walk you through filing a charge of discrimination. And then the EEOC then has the authority and the charge to then go and investigate that situation. And I think that based on the guidance that we've seen and the Algorithmic Fairness Initiative, I think that it's fair to say that this is a topic of interest to the EEOC. So individuals who feel as though that they have been discriminated against will, I think, get a receptive hearing from EEOC. I think that there'll be attention paid to these sorts of allegations. But certainly, as a legal matter, that's how you go and vindicate your rights. If you feel as though you've been discriminated against, you go to the EEOC, you file a charge, and then they investigate going forward.
This is Lydia. And Riddhi, would you add anything to Pierce's suggestions?
I would just, Pierce really covered the options that are available to applicants and to employees. The one thing I would really reiterate is that even while we advise this, we still want to make sure that it's clear the onus should always be on employers and vendors in the way these tools are being designed and adopted, and in the kind of hiring priorities that are being really designed into the way these tools work and the way they evaluate workers. So even though there absolutely needs to be clarity in applicants' recourse when they've been discriminated against, there also has to be a way more proactive effort on the part of employers and vendors to really design these tools in a way that takes into account the expertise of people who will be affected. So, making sure that disabled experts are part of the design team, making sure that any feedback from applicants with disabilities about how tools worked previously is used to kind of improve the way the tool works going forward. Employers should really kind of think of that as putting themselves on notice that their tools actually may be discriminatory and need to be changed going forward. And things like providing accommodations, there are even limitations there when you're using some of these tools, because a lot of accommodations won't be helpful in the way these tools work, and also wouldn't necessarily reflect the kind of accommodations that the same worker may have if they were on the job. So it really needs a broader kind of examination on the part of the employer and thinking about how their tools are going to affect qualified applicants who may just be screened out because they have a disability that would not affect how they'd be performing on the job.
This is Lydia. Thank you all for sharing such great insights today. And, Ridley, of course, we work together all the time, but Dradier and Pierce, it's really been great to get this chance to spend some time with you and hear from you today. Now, we have a number of questions that have come in from our participants today, and I will exercise moderator's privilege and take the first one of those. I know that this anonymous person's been waiting for a while. They asked, could you discuss language referring to someone as a disabled person versus a person with a disability? I'm hearing the use of the first term in this panel, but I've been told this was offensive. So I want to note for folks who are hearing this and who perhaps have encountered those similar kinds of comments in the past, perhaps in a disability etiquette training that you may have taken, that it is very common for people in the disability community to use both person first language, people with disabilities or person with a disability, and what we call identity first language, disabled people or disabled person. There are different historical and political reasons why some communities of people with disabilities have preferred person first, and why other communities of disabled people have preferred identity first. Personally, as someone who is disabled and uses identity first language most of the time, especially when I'm talking about myself and many people in my communities, the reason that I do that is because I do not believe that disability is inherently stigmatizing or a negative or degrading experience. And if I wouldn't be described as a person with Asianness or a person with queerness, because most of us, at least I hope within CRSJ, would understand that if I'm referred to as an Asian advocate or as a queer attorney, that I'm not being reduced only to my race or my sexuality, and I'm not being negatively described by referencing my race or my sexuality, then I don't know why we wouldn't extend that same recognition of disability when I'm referred to as a disabled person, that's not reducing me only to my disability status, nor is it referring to me in a negative way. And similar to referencing my race, my sexuality, or my sexuality, referencing my disability doesn't necessarily mean that's the only relevant characteristic about me or in my life, but it does mean that it's something important to me. It might be an important or relevant identifier. And it is one that recognizes there is nothing inherently shameful, embarrassing, or negative about any of those characteristics. And so that is why, for me, it is very important that we destigmatize the idea of disability, in part through refusing to avoid saying the terms disabled person or disabled people, because avoiding using that phrase out of a fear that it might be offensive actually reinforces the idea that disability is something that should be stigmatized. We have another question from a different anonymous person who asks, with the growth of AI and Google's collection of data on students' behavior and ed data added to other biometrics, will we see an explosion of discrimination? And for this one, I'll turn first to Riddhi.
I would argue that we already have. As we've been discussing during this conversation, you see how, for instance, employment history can be used in making decisions in tenant screening, making decisions about access to credit, and that kind of turns back around and then affects access to employment too, because if you can't access housing, that's going to affect your ability to make it to work on time and to be able to hold on a job as well. So there is that loop, and that extends to other sectors too. In education, with the kind of range of tools that are used to monitor student activity, there are greater risks, particularly for students who are already kind of overly disciplined, overly policed in school settings, whether it's because of the use of facial recognition on school campuses, or the use of remote proctoring that forces students to kind of expose more of their living space, especially now in the pandemic and new pandemic reality, where remote examination has become, and remote learning has become kind of more commonplace. In these contexts, it does end up exposing more data, and does so in a way that doesn't necessarily safeguard the data of students that are kind of being made more vulnerable through these practices. So I think, down the road, then these kinds of technologies that will end up compounding the effects of over-policing against particularly Black and Brown students and disabled Black and Brown students, that will kind of, that's the beginning of the kind of pipeline that then eventually affects job prospects, affects their ability to go to kind of pursue the majors that they would like to pursue when they choose to pursue higher education. That will affect decisions that are being made in other areas too. So, education data in general, and how these kinds of tools can impact education data will then also feed into decisions in other contexts. So you have the tools that are discriminating kind of in the moment, and the tools that are going to impact data that's being used down the road in other contexts too.
I absolutely agree with your assessment that discrimination is absolutely already happening. We have a question from MG Masterson, who says, are stored proficiency tests like Indeed or DICE made available to employers as an applicant applies? Are those tests compliant, where the only accommodation request is a checkbox after the results are sent? As a person on the spectrum, which I'm assuming you mean the autism spectrum, just reading from that, it seems redundant or defeats the purpose. Dre, dear, would you be able to take that question?
Yeah, sure. It probably depends on what they do after, right? So if you say after that you need an accommodation, hopefully they throw out whatever the result of that was and judge your application from scratch with the with the accommodation after they reach out to you and see what you need. But it probably depends. I'm sure there's an argument there that for wasting someone's time, having to take the test first, and then start over. Depends on what the accommodation needs to be, but potentially having to start over in a new process. So it probably depends on what the company does after.
Thank you so much for sharing that. I hope that for those of you who've asked questions, that this was helpful to you. We do have a couple more questions, but we are basically out of time now. But you are welcome to reach out to any of us later with those additional questions if you all are comfortable to share your contact information in the chat for our participants. As we close out, I want to thank everybody for joining us for today's free webinar. I'd like to express our gratitude to Dre Deer, to Pierce, and to Ridley, our very esteemed group of panelists. All of you are doing such critical work. And we thank you for taking time out of your schedule to share your experiences and your expertise. ABA's section of Civil Rights and Social Justice provides free webinars and resources for legal professionals and advocates nationwide. We hope that this is helpful to you in your work. And again, if you can, please consider joining and becoming an active member within the ABA. You can do so at ambar.org/CRSJ. Best of luck in all of your work, and please stay safe. I hope that you have some delicious food in your